day we are able to embrace the challenges of today. I'm going to share for 40 minutes, and then we are going to have 20 minutes of the plenary session, which will take us a long way. So, ladies and gentlemen, I'm going to split my discussion in 3 sections. I'll begin with the marriage law, and then I'll swap to the Divorce Act and its legal and social implication. And then I'll seal it with the aspects of how you draft a will that are critical under the Succession Act. Without wasting so much time, marriage is basically a union between a man and a woman that has been undertaken under legally recognized event. And in Uganda, we have quite a number of marriages that are recognized in Uganda. The legal framework that basically governs marriages is a Marriage Act. And then we have a customary, law that governs the customary marriages. And then we also have the Hindu and Muhammadan Act that critically looks at the marriages under the Islamic faith. But allow me to mainly focus on the marriages under the civil and then our customary marriages that are governed by the Customary Marriage Registration Act. I don't want to sound so legal, so I'm going to make it so simple and palatable so that you can pick, we can enjoy the conversation and, interrogate ourselves on the marriage law. So, ladies and gentlemen, marriage is a voluntary union, between a husband and wife. And like I said, it should have a it should have an existing legal recognition in form of its marriage. And you'll ask me that why do people marry? Why do they subject themselves to the legalities of a marital union? It's quite a number of reasons. People marry for companionship, so that they have protection of the law, so that they are able to leverage on the strength of one another in terms of investment, so that they're able to improve on their social status. Other people marry so that they can have security, so that they can be able to have consummation, which is sex within the confines of a clearly, a clear marital union, and also for people to be able to start a family. So there are quite a number of reasons. It's a question of fact. It depends on who you are and the purpose for which you're going to undertake a marriage. And like I've earlier on shared, that we have quite a number of types of marriages in Uganda. I'll stick to the civil marriage, and this is a marriage that is celebrated under the Registrar of Marriages. These ones are conducted basically under the Registrar General or his appointees. It's called a civil marriage, and basically most of the marriages that we conduct under the church have been linked to the Registrar of Marriages. That's why some churches normally give us 2 certificates. The smaller long one that is from the Registrar of Marriages records, and then the decorative one that is formally used with us for some of us who got married years back. And then we have customary or church marriage. It is celebrated in a licensed place of worship, and it is recognized by a minister, a priest, a reverend, a pastor. Those are the church marriages that we have. And then we also have a customary marriage, a marriage that is solemnized according to the customs and the rights of a particular sect, community, or a tribe. And these ones vary, as well as the Muhammadan marriages. These are marriages that are basically inclined to the Islamic faith, and it allows the marriage to follow the Muhammadan Act, etc. So, ladies and gentlemen, the key question is here: what are the requirements, or what are the legal considerations, or what are the prevalent conditions that are important when it comes to a marriage? One, if you look at our constitution, it requires that a person should be above 18 years, and that for you to be able to be part of a marriage or wed and get married to somebody. And our Marriage Act basically considers the age as 21 years. Yes. And the law is very clear that a marriage has to be conducted by an authorized person. For example, if you're going to conduct a civil marriage, the Registrar of Marriages under the Registrar General normally appoints or instructs particular state attorneys that conduct these marriages at the Registrar General's offices. And then when it comes to the church marriage, it's normally solemnized by a minister, a recognized person. And allow me to emphasize that a church marriage has to be in a licensed place. Unfortunately, sometimes people have gone to some churches that are not licensed, and they end up having a marriage that is not legal within the confines of the law, because a legal marriage should be under licensed place by an authorized person, so that at the end of the day, you have a certificate as proof of your marriage. So basically, there are key requirements of a marriage. Is it witnessed by two adults of sound mind?
Long life.
Can you mute yourselves, please, so that we can continue? Thank you. Allow me to proceed. So I was saying that the conditions are very, very important, because once you don't follow those conditions, then your marriage can be, deemed a nullity. For example, if your marriage was in a place that wasn't licensed, or if your marriage was conducted by a person who is not authorized under the law, is not a minister in terms of being a priest or a reverend, and the church is not recognized, then of course it becomes an invalid marriage at the onset. Then also the aspect of consent and voluntariness. Remember, it is a voluntary union. You're not to be coerced into it. A person should not be, pushed into it. It should be voluntary for all intents and purposes. So ladies and gentlemen, the key area here to reconsider is, if these conditions are being complied with, then that means that the person is lawfully married to the other person. And allow me to say that a marriage union under civil, under church, and under the Muhammadan Act, that is under the Islamic faith, has certain rights that the parties enjoy. And what are these rights? The first and most important right is that normally the wife enjoys a right to use the name of the spouse. That's why we adopt some of these names. You have your own old name, and then all of a sudden you're able to pick a name of your spouse. Then there is also a right to begin and initiate what we call matrimonial property. You're able to acquire property both, but similarly, in the current, case law we have, you're also able to enjoy a right of ownership of your own property within the confines of a marriage. So besides that, a marriage also confers upon you a right to be able to share on the properties that have been acquired in the subsistence of a marriage, especially during and after the dissolution of a marriage. This is very critical. I'll hint on it later when I'm talking about divorce. And similarly, there's a right of having children born within the marriage, okay? And they're presumed to be a central part of that marriage. So the marriage in itself renders certain rights of protection, security, okay, in terms of property. And you also enjoy a right of being able to come together and be able to start a family as a couple. So a marriage infers a number of rights on the individuals, and which is very, very important for us to have a conversation on. Their rights and obligations, the entitlements that happen when you become married to somebody. And ladies and gentlemen, once a marriage has been solemnized and there's a certificate that has been issued, it cannot be dissolved as easy as it was started. That's why we have particular procedures that I don't want to go through, because under the civil marriage, there are procedures under the Register of Marriages, there are procedures under the church and there are also procedures under the Mohammedan Act. So I'll not go deep into those details for purposes of this short Now, when a marriage starts and commences, the only thing that can shortcut a marriage that has started between a parties voluntarily, willingly, happily, is what we call a divorce. It's what we call dissolution of a marriage, okay? They should be able to have what we call conjugal rights in law. So if this couple has not had sex ever since they got married, then that is a substantial ground for dissolution of a marriage. Why? Because they've not actually sealed, they've not broken the ice in the marriage. So definitely nothing has started, because sex, even in the law space, is a key aspect of marriage. It's part and parcel of marriage. You can't say you're married to somebody, but you've not yet consummated. So that is a very good ground, failure to consummate the marriage, but that doesn't matter. If you spend like a week before you consummate it, you can't say, well, when honeymoon started, we didn't consummate. No. If you probably consummated after a week or two, still the marriage was validated by the consummation or the sex that you had. And after the 6 months, if you come back to court and say, actually, we are so determined to dissolve this marriage, my lord, or your worship, then court will go ahead to give what they call a decree absolute. Now, the decree absolute has legal implication, ladies and gentlemen. It means that the marriage is over. It means you can no longer claim so-and-so as your wife and husband. They are free to remarry. It means that the property, which was part of the divorce, it means, is it okay? Just a minute, we're trying to remove this. My unmute. My apologies. My apologies. We had just a glimpse of our network, but I think I'd stopped where we're saying what happens after divorce. Welcome back, ladies and gentlemen. I said when a marriage has been dissolved, it means that the marriage is over for all intents and purposes. It means that you can no longer have conjugal rights unless you want to start something else, okay? It means that the spouse you've divorced is free to relate with anybody else. You know, for us lawyers, we have instances where clients come back and say, I saw my ex-wife having a good time in Governor. Can we ask police to arrest her? I saw my husband going to introduce so-and-so. Can we? I'm having issues with the network. What you just do? During the subsistence of a marriage. For example, if you acquired property, immediately you got married together with your husband, then it is deemed matrimonial. For example, we acquired this house. Now this is matrimonial property for all intents and purposes. Of course, there are times people go to court and say, before I got this house, before I actually married Joyce, I had this house and owned it. Well, those issues are resolved by court. We normally refer them to court so that court can be able to resolve them and they determine. But property that is deemed matrimonial property, what I want us to capture is divided between the wife and the husband at 50%. Okay? So this is very, very important for us to know. I may not be able to answer every question to do with this property matrimonial. This property. When it comes to divorce, some issues cannot be determined. It's not a cast in stone. It's a question of depends on the evidence adduced in court during divorce, and court will make a decision. Some things cannot be, because I get friends to ask me, do you think that this is my plot of land I bought in my name? It will be a question that court is going to raise. Okay, but allow me to also mention. There's an echo. Allow me to also mention. Let me try to resolve that echo. Okay. Allow me to mention that even in the subsistence of a marriage, you can have individually owned property. For example, if I bought a plot of land in Joyce Nalunga, it's my property. If Mr. Bidi Mumaso has acquired a plot of land in his names, it's for Mr. Bidi Mumaso. But if we decide to buy a plot of land together, it has Joyce Nalunga Bidi Mumaso and Joseph Bidi Mumaso, then it becomes family property. Hello. So you can acquire property individually, and you can also acquire property matrimonially, if I may use that word, if it's correct. Okay. And of course, a dissolution, court will weigh the facts, it will weigh the evidence, it will weigh the information, and it will be able to interpret the law as regards the petition when it comes to that. So that's why I was saying that there is property. Then also another critical area during dissolution is the area of children, custody. Ladies and gentlemen, this is one of the most controversial areas in dissolution of a marriage. I've handled, before I joined the tribunal, I used to handle quite a number of divorces, custody of children of tender years, custody of children that are about 16, 18, 20. It becomes so controversial. Unfortunately, most couples want to use the children as a tool in dissolution of the marriage. May I caution the participants here that God forbid if you decide to dissolve your marriage, do not use the children as a tool. Consider your relationship separate from the children. Do not use the children to fight the other spouse, and do not use the children as a win-win situation. Let the children be honored and respected as children, because the children will never take sides when it comes to divorce. Why? Because they remain with a loyalty with either party. So for me, that is the most important aspect. So when court grants a decree absolute or a decree nisi, they are very, very careful about the children. Who is going to have custody? Lately, most courts, take the word most, they prefer joint custody. Why? Because they don't want the children to miss the love from either party. They want the children, much as the marriage has dissolved, to be able to access the children. They want the children to be able to enjoy their birthday parties with their dad and mom, despite the fact that they're no longer husband and wife. So that is a very important aspect. So I don't want to go through so much nitty-gritty, but I wanted to emphasize that there are legal implications of a dissolution of a marriage to do with the name use. There's a divorce I've ever handled in court where the man said that upon dissolution of this marriage, I don't want the woman to use my name. So that can also affect the parties. I've talked about property. I've talked about the children. Allow me to hint on what we call separation. Ladies and gentlemen, divorce sometimes is the climax of the dissolution, but the law allows what we call separation, a temporary relief of the spouses from their marital duties for a specified period. The key word is temporary relief of the spouses of their marital obligations for a specific period. Okay? And if you look at the Divorce Act, it talks about what we call judicial separation or separation by agreement. Maybe I take off my video. Allow me to take off my video so that probably the network, Zoom does not affect the presentation. So we have quite a number of types of separation under the law. I say judicial, and I also talked about separation by agreement. When I was still in active practice before I joined the tribunal, where I don't actually do practice, we could engage couples that come and say, I need to separate with my husband for the next 5 years. I need temporary relief. And I want us to agree that the children will access all of us. I want us to agree that he's going to keep this home for the children. You have particular terms you agree upon. That is what they call separation by agreement. You can even agree that we are not going to have sex in the next 5 years so that we can weigh and see whether we are tired of each other. Okay? And most importantly, that the key aspect is parties also agree whether they will allow the other parties to enjoy conjugal rights elsewhere. But of course, as long as a marriage has not been dissolved, you cannot commit a marital offense of adultery. So that is very, very important, that even where there is separation, the law still honors the marital union. So it cannot condone marital offenses of adultery. Then there is judicial separation. Okay, judicial separation is very clear, is where the parties petition court that we want to separate for 10 years, subject to the following terms and conditions. So all those happen in court. So ladies and gentlemen, you may ask me, how long does a separation take? Like I said earlier, it is a question of agreement of the parties. If the parties agree that it's going to take 2 years, 4 years, 5 years, 10 years, so be it, because they are agreeing on a temporary relief for a specified period of time. And when the period lapses, then they can be able to notify court if it's a judicial separation that now we are ready to resume our marriage. So I thought I'll discuss those simple areas under the family law so that we are able to have a conversation. I cannot go so much into the detail of the procedure, specific details, because that would be like I'm taking the participants through a class under family law, you know, on procedure. But I thought we would have just a debrief, an abridged version of what happens here and there. And then lastly, I'll talk about something very critical under the succession law, something called, you know, a will. I've had quite a number of discussions on a will. I'm not going to go so much into detail, but a will is a last testament of a person. Is a last testament of a person. It is a last document a person makes before his or her death, directing how his property and other affairs are going to be taken care of. Okay? And a will must be valid. It means that the will has to be done voluntarily. You decided to make your will. You must understand clearly what you're writing, you have a mental sound. And allow me to emphasize that the law clearly says that any person aged 21 years or over and is of sound mind can make a will. Okay? They can make a will because they are competent. The other question is, how do you make a will? Ladies and gentlemen, a will is very important, especially in this era and age of the COVID pandemic, where people pass on within a twinkling of an eye. Okay? So it is important. It gives security of the family. It protects your family from greedy relatives and friends. It protects your children. It prepares your children for a better future. It positions your children to be able to mourn, but at least with consolation that daddy and mommy have gone, but at least we have something that will be able to educate us. Okay? A will protect your legacy. It protects your investments. It protects your name. It protects your brand. A will is a very important document. We should not fear to make a will, because some people think that if I make a will, it means I'm going to pop tomorrow and pass on. No, a will is so important right now. And how do you make a will? You make a will when you make a writing on your property, your information. I'm Joyce Nalunga. My parents are so-and-so. My siblings are 6. They are so-and-so. I own this immovable property. I own this movable property. I have a car number plate, this. I have a plot of land. I have shares in an investment club. I have this and this and this. And for the men, it's important for you to mention that I have these children with my legal wife, so-and-so. But before we got married, I also got these children. However, also in the subsistence of a marriage, things happen, and I also got these children. Because at the end of the day, the law considers all the children as children. So you need to have their security, your legacy, and so that they're able to benefit from the will. Now, the contents of a will are very critical. Description of the testator. A person who makes a will is called a testator. Their addresses. Beneficiaries, who are your beneficiaries in the will? Beneficiaries regards your biological children and then your non-biological. Like I have adopted children here, 5 of them. It's important for me to clearly indicate them in a will. These are my adopted children of my late sister, so-and-so. These are children of my so-and-so. You know, if your parents are still alive and they are dependent on you, then also include them in the will as dependents, okay? And the will also includes what we call a bequest, distribution of your property. What are you leaving for the heir? What are you leaving for your son? What are you leaving for your wife? What are you leaving? What percentages? If you have shares in a company, how much shares are you giving to your children, to your wife? You know, it kind of protects your will. So I'm going to summarize, because the 40 minutes are done for my presentation, so that I can look at the questions in the 20 minutes. So a will, according to the Succession Act, is written, okay? However, when you look at the act, it talks about a will by a mariner or a soldier that is at war, what we call a privileged will. I'll not go so much into that. That is being so technical and getting legal. But after you write a will, it's important for you to date it. It should be signed by a minimum of 2 witnesses, okay? And there should not be beneficiaries. Like I can't make a will and my son is a witness. No, he's already a beneficiary in my will. It should be by independent people. So it's good for you if the pages are 10, sign and initial every page. If possible, put a thumb mark so that it is really authentic and you protect it from forgery, okay? And get independent witnesses. Also have what we call executors in your will. These are persons you believe are competent, credible, capable of enforcing the requirements of your will, okay? These are the executors in your will. Now, the other question is, what happens if along the way, maybe I made my will in 2019 and in 2021, I buy shares in an investment club? You do what they call a codicil. You write another document to accompany your will and specify and say, whereas I made a will in 2019, in 2021, I've acquired shares in Bank of Baroda, so I accordingly find this codicil as part and parcel of my will. So you basically try as much as possible to add it there. So I wanted to just paraphrase those aspects of a will, but what is of paramount importance, approach an advocate, approach lawyers so that they are able to help you draft a will and make it very authentic within the confines of the law. Someone is already asking that, can it be witnessed by 3 people? I said minimum 2, but it can stretch to 3, 4, 5, okay? Depending, but it should be witnessed by minimum of 2. You can't say a will has been witnessed by 1. It renders it null and void if it is witnessed by 1 person. So ladies and gentlemen, that was a brief discussion on marriage, divorce, and then the will under the Succession Act. So what I wanted to now consider is the question that are being posed by the various participants. And someone has asked a question. Can you please mute? There's someone, before I mute everyone, can you please mute? Thank you, Irene. Now someone is asking, can an audio be a will? According to the Succession Act, a will is written down, okay? A will is properly written down so that it is articulate, and it has to be witnessed properly so that the people can be able to understand and articulate the issues. I'll be able to answer some of the questions here so that I'm able to address them. Someone is asking, why does court sometimes fail to resolve cases of divorce and other options? Ladies and gentlemen, I cannot answer for the courts of law, but what I can say that sometimes courts are overwhelmed with backlog, etc., and matters cannot be resolved as and when the parties wish. So that is all I can say briefly. And if you look at sometimes the reports that are being issued by the Chief Justice, they explain why sometimes there is a delay in disposing cases. Now, someone is also asking, in case of adultery where a husband moves out of the marriage to stay with another woman, what happens? Ladies and gentlemen, like I said, divorce is a personal decision. You cannot divorce based on your lawyer. You cannot divorce based on your parents. You cannot divorce. What is of paramount importance? Do you want the marriage to stop at that stage because of the decision, or you want to continue? Because remember, if a man has moved out to another woman, then that is adultery. But like I said, it's a person to hold that decision. So it will depend on what you decide. I cannot even decide it here on a chat that please go ahead and do this and that. No. You need to own it up. I don't want somebody to say, oh, but Joyce said that you can do this and that. No, it's a person to hold up. Okay, so it's good you this internet. Someone is also asking a question. What about a situation where I buy land in my name and we build a matrimonial house on it? Does it become family or mine? Aisha, what I can say is that once you buy the land and then you build a matrimonial home, you know, in land law, we have what they call that every fixture on the land becomes part and parcel of the land. In my view, that becomes family land because you've put what they call a matrimonial house. So you cannot turn around and say, let us cut off the house and we leave the land. So it becomes matrimonial property because it's a fixture, a permanent fixture on the land, and then it becomes part and parcel. Then someone is asking here, okay, I'm trying to look at, Irene is asking a question. I want to understand, that is Irene, what happens in case I want a divorce and realize that my marriage wasn't registered by a church in the government? Now, if a marriage was not registered in a church in government, if a church, your church where they solemnized the marriage was not valid, it was not legally recognized, it wasn't licensed, then that marriage does not have a legal foundation in the eyes of the law. Meaning that what are you seeking? The only thing you seek in court is a nullity, to consider the marriage you've had as being a nullity. It's null and void. Why? Because it was solemnized under a church that was not licensed, which is contrary to the provisions of the Marriage Act. I've already emphasized, Anne Namakula, thank you. I've emphasized the purpose of a will. I've already, can I make someone is asking Vero, can I make a board of trustees instead to ensure property is kept? Yes, that is very good. You can have a trustees that is provided for under the trustees, act, where you can say that I'm formulating a trust of 7 people. Upon my demise, all my property should be under the trust for purposes of educating my children until the last one gets married. Then my children can make a decision on the next step of the property. Someone is asking, is it recommended to have a different set of witnesses for all the 3 copies? No, Nelly. Thank you very much. You're supposed to have the same witnesses for all your 3 copies. Otherwise, it's confusion. The law says same witnesses. So basically, you're making 3 copies of the same document, just have the same witnesses. Then Sarah is asking, in case of failure to write a will, can they refer to an IGG declaration? No, the IGG declaration form cannot substitute a will. A will is under the Succession Act, and it is the written last testament of the testator. Now, someone else is also asking a question that if a spouse deliberately omits the children and the wife in a will, is that will authentic? The will remains authentic, but court can make an order that the spouse and the children are considered as beneficiaries, okay? Actually, a will is challenged in court where it is not fair, where it is unjust, where it is basically, is challenging the rules of natural justice. So where the man has deliberately, for example, if someone dies and leaves out the official wife, then the court can still consider the will authentic, but consider that whatever properties are being mentioned are subject to being shared by the beneficiaries. And someone is asking, what happens to the property which was acquired together, it is divided 50-50. Catherine is asking, what happens if one party refuses to agree to a divorce? Must there be consent? No, there shouldn't be consent per se. If parties, one is refusing and the other one is agreeing, then like I said earlier, court will decide depending on the merits of every case. If court finds that the grounds have been proved by the petitioner beyond reasonable doubt, on a balance of probability, then court will subsequently allow the divorce even if the other party had refused outrightly. Then someone else is asking, Flavia, what can happen if the beneficiaries think property was not distributed fairly in a will? Flavia, if property was not distributed fairly, petition court to consider the aspects of the will that are fair and those that are unfair, so that the beneficiaries' interests are catered for. And Maria is asking, is all property acquired in the marriage considered joint, even if one uses their money? I discussed this earlier on, Maria. I said, even in a subsistence of a marriage, parties can own property, okay? And also parties can own joint property. I have so many properties I own as me. My husband has so many properties he owns as him, but we also have joint property, okay? Then would it be in order, this is Irene, would it be in order for a spouse to write a will on properties that are considered matrimonial property, e.g. give it to a child? Well, the law is very clear. Matrimonial property has a 50% share of your spouse. So when someone is making a will, normally court considers their 50% as a share. So you cannot bequeath in a will what doesn't belong to you. You can only bequeath what belongs to you. So the other 50% is for your spouse. And if you bequeath your half to your child, so be it. And then Diana is also asking, can I register my property under company? Can I register my property under company so it's jointly managed by the company? Yeah, I think you can register property under company, because under company law, a company owns property on its own, separate from the directors. So if a company owns a property, then that's not personal property, neither is it matrimonial property, but it's company property that is owned by the shareholders in the different percentages that they hold. Okay. I'm winding up with the questions because it was supposed to be a 1-hour discussion. And someone is asking, if an heir of a family inherits land on which the burial site sits, then he and his wife build the matrimonial home on that land. What happens to the wife in case the husband dies? This, ladies and gentlemen, I want to emphasize that under the Succession Act, the heir is a trustee for the beneficiaries. He's a trustee for the beneficiaries. That's why the heir under the Succession Act only gets 1%. He doesn't get beyond 1%. If a person has died intestate without any property, then the heir gets 1%, the legal wife 15%, and all the children share 75%. So the heir and the widow, when it comes to the matrimonial home, that is the home of the widow and widower, they own it as trustees for the beneficiaries. So if an heir has constructed a house on property owns as a trustee, then he has mingled the ownership, and that's going to be very controversial, okay? Because that is not property owns as him. He owns it in trust for the person who appointed him as heir under customary law. So this is very, very important. An heir cannot own a burial site. Why? Because he's a trustee for the rest. That is why he has 1%, okay? And the wife of the heir cannot claim that this is our property. Why? Because the property was owned by the husband who is an heir. As a trustee for the beneficiary, it doesn't belong to the heir's estate in any way, okay? So ladies and gentlemen, as I conclude, there are quite a number of questions. I'm trying to go through them. Someone is asking a question, if rentals are built on land inherited from family by the couple, is it considered matrimonial property? You know, that's why it's very important for couples to be very clear and articulate when it comes to property ownership and interests. If you inherited property from your family, that is family land. Why would you allow now you and your husband to build on a family property, rentals? You're mingling ownership. You're brewing a strife that is going to happen tomorrow, okay? Because now it will be your family, my family of Joyce, battling with, my husband over property, because the foundation is shaky. What I can tell the participants, it's very important for you right at the onset to be very, very clear on ownership aspects, on interest aspects. If a property, land has the interest of my siblings, that is my family, then I should not drag my husband to come and build rentals there. Why? Because my siblings are going to always have issues with my husband, God forbid. If I pass on, my husband, it will be hard for him to claim that property. Why? It is family property from my father or my mother. So it's very good for you to be very, very clear. Okay? Then I'm trying to wind up, I think. Ladies and gentlemen, time is running out pretty fast. I just have only 5 minutes to address some questions I've not answered. There are quite many, but I think I've tried to summarize some of the key areas. What is of paramount importance is make sure you, for starters, you regularize your marriage, have it legal. There's nothing like cohabitation, okay? You can't say because you've had twins with a gentleman for the last 20 years that there's a presumption of marriage. No, sweetheart, it has to be a legal marriage. Either go to church, a legally recognized church with a legally authorized minister, a priest, a reverend, a pastor to be able to solemnize the marriage. You can also go to the Registrar General under the Registrar Marriage and legalize the marriage. Why? You stand to lose more when you're moving in a cohabitation. You stand to lose more in terms of property, in terms of security, in terms of ownership when it comes to you enjoying that marriage. So it's very good that at the end of that day, we are able to benefit from this conversation by trying to find the legal way of making everything quite important. Then also when it comes to divorce, this is the take home. Divorce means dissolution of a marriage. Divorce simply means that the parties are not going to be able to enjoy the former rights and obligations they previously had. So the take home is, are you ready for it? Are you ready to relinquish those rights? Can you mediate? Can you resolve it? If you can't resolve it, then so be it. Resort to court so that at the end of the day, court can be able to dissolve the marriage. Then lastly, when it comes to the will, ladies and gentlemen, I've said this over and over again. Make sure you have a last testament. Make sure you have executors in your will. Make sure you write down every property you have. Make sure it is properly witnessed. It is important so that at least your children will be able to benefit from your sweat. If you pass on without a will, children are at the mercy of your friends, they're at the mercy of the family, your wife is at the mercy of the in-laws. So a will is a non-negotiable instrument when it comes to succession. I believe I've tried to handle, I don't want to take so much time because I wanted to take only 1 hour, and allow me to appreciate each one of you. Thank you so much for taking off time to have a conversation with me. Thank you for the questions. They're very, very important. And I believe I've tried to answer some of the questions. I could not exhaust all of them. There are quite many, but I'll try as much as possible to reach out to each one of you. You can use my number and reach out to me inbox. I'll be able to answer some of those things. Let us try as much as possible to organize ourselves. Let us leave a legacy. Let us be visionary. Let us be organized for purposes of our legacy. Thank you and have a very blessed good night. Good evening to all of you. Hi to the members of the Leadership Code Tribunal, and hi to the Trinity College Nabingo class 1990-1996. Thank you so much. Bye-bye, dears.
Thank you so much. We have been pleasured to be part of this beneficial meeting of this evening, and we pray that we continue with this. We shall be part of the celebration, and we pray to God that keeps us alive, such that by every time we get some time and you'd like us to meet on Zoom, we can meet up and share some great ideas. For sure, there are things that really the person can stand back having questions, but those questions are not answered. So when we are in such a commitment and someone is able to render advice on something, someone comes out benefiting. So it has been a great honor and privilege to be part of today's meeting. Thank you so much. That seems we missed out on